All right, strap in, everybody, because today we are going deep on something called the Revised Uniform Residential Landlord and Tenant Act,
Yeah.
RURLTA, for those in the know. But, most people are not in the know, so we'll just call it RRLTA.
Right.
It's like the updated rule book for everything renting.
Mm-hmm.
And we're here to break it all down for you,
Yeah.
whether you're the one paying the rent or the one collecting it.
Absolutely. This is not exactly a beach read.
Sure.
So we have done the hard work and sifted through all the legal jargon to bring you the need-to-know changes from that old 1972 version.
Yeah.
We're talking about security deposits, protections for tenants who are dealing with domestic violence, even what happens if a tenant passes away.
Right.
Sensitive stuff, but, important to be aware of.
Yeah. And you know what? I think you'll be surprised by some of these changes.
Mm-hmm.
Could save you some serious headaches, maybe even some money down the line.
Absolutely.
And we'll get into how RURLTA tries to keep things fair for both sides.
Yeah, for sure.
Speaking of fair play, we really appreciate you joining us for this deep dive.
Yeah.
Hitting that subscribe button honestly means the world to us. Helps us keep bringing you these in-depth looks at all these topics you care about.
Right.
All right, let's get into it.
Let's do it.
Okay, let's talk about money.
Always a good topic.
Always a good topic, right? Security deposits.
Yeah.
Always feels like there's a bit of tension around that.
For sure. Yeah, it's a classic landlord-tenant sticking point.
Yeah.
But RURLTA tackles this head on.
Okay.
It brings some much-needed clarity.
Okay.
First off, it establishes that your security deposit is not just some random pot of money that the landlord can dip into whenever they want.
Right.
It's actually considered a security interest.
Okay, wait, hold on.
Yeah.
Security interest.
Yeah.
What does that actually mean?
Yeah.
For me, the person handing over my hard-earned cash.
Right. Think of it this way. Your security deposit is like money locked in a safe.
Okay.
Even if the landlord hits hard times, let's say they file for bankruptcy.
Right. Your deposit is protected.
Okay.
And RURLTA also sets clear limits on how much a landlord can ask for.
Okay.
No more than twice the monthly rent.
Okay.
And that's excluding the first month's rent.
So first and last month's rent plus a security deposit equal to 1 month's rent, that would be okay.
That's right. That's right.
Okay.
But there are a couple of exceptions.
Okay.
Landlords can ask for a bit more if you have a pet,
Sure.
or if you're allowed to make alterations to the property
Okay.
just to cover any potential damage.
Makes sense.
And to prevent any funny business, RURLTA requires landlords to put those security deposits in separate bank accounts and keep detailed records.
Ah, so no more shady dealings. I like it.
Transparency is key.
Yes.
And when your lease is up, landlords have 30 days to return that deposit,
Okay.
along with a detailed list of any deductions for damages.
Right.
And if they don't follow those rules, they could face some penalties.
Good.
Definitely helps keep everyone honest. That's good to know. But what happens if the property is sold while I'm renting?
Yeah.
What happens to my deposit then?
Great question. RURLTA has that covered too.
Okay.
If your lease continues under the new owner, the old landlord is legally obligated to transfer your deposit.
Oh.
If your lease ends, they have to return it directly to you.
Gotcha.
And the new owner basically inherits all the responsibility regarding that deposit.
Okay.
It's a well-thought-out system.
So RURLTA is bringing some serious clarity
Yes,
and fairness to this whole security deposit situation.
absolutely.
Both tenants and landlords are on much more solid ground now.
Absolutely. But RURLTA goes beyond just the financial side of things.
Okay.
It also addresses some very sensitive situations,
Like
when a tenant is experiencing domestic violence.
So this is beyond the typical
Exactly.
landlord-tenant
Yeah,
disagreements.
exactly.
This is about safety.
You got it. RURLTA recognizes that a tenant's safety is paramount. So imagine you're in a situation where you need to leave your home for your own safety.
Right.
RURLTA provides a way out.
Okay.
It allows you to break your lease without penalty.
That's huge
Yeah.
for someone in that situation.
Yeah.
Huge.
Yeah.
But I imagine there's a process.
There is. You'll need to formally notify your landlord
Okay.
and provide documentation like
Yeah.
a restraining order, conviction records, verification from law enforcement, or a victim advocate.
Right. Okay.
Once you've done that, you shouldn't have any further rent obligations,
Okay.
except for what you owed before terminating the lease.
Right.
And your security deposit should be returned.
That's so important to know that there is a legal way out
Yeah.
without being, financially penalized
Right.
on top of everything else.
Absolutely.
What if there are multiple people on the lease?
That's a good point.
Yeah.
If there are multiple tenants on the lease continues for the others.
Okay.
But they may have legal options against the perpetrator
Oh,
to try and recoup their share of the rent.
so it's about finding a balance.
Exactly.
Right.
Okay.
Protecting the individual, but also acknowledging that, the legal agreements are in place.
Yes.
What of the person who committed the violence?
Right.
Are they off the hook?
Not at all.
Okay.
RURLTA allows landlords to terminate their lease without a court order.
Wow.
If there's a reasonable belief they were violent towards another tenant in the building,
Okay.
and they are held responsible for any damage
Right.
and the remaining lease obligations.
So ensuring accountability,
Yes.
allowing the landlord to take action to protect the other residents.
That's right.
Okay, our RLTA is tackling some really
Yeah,
complex and sensitive issues here.
it is.
What else should we be aware of?
Well, let's talk about something that's not easy to discuss, but, unfortunately, these situations do happen.
Okay.
RLTA provides guidance on what happens when a tenant passes away.
Okay, this is not exactly light dinner conversation, but it is.
It's important.
Very important.
I'm guessing things were pretty murky legally before RLTA.
You're right. Yeah, this area was pretty ambiguous.
Yeah.
But now with RLT, both the landlord and a representative of the deceased tenant can end the lease with proper notice,
Okay.
usually around 30 days for a fixed-term lease.
What if the deceased tenant had a spouse living there who wasn't on the lease?
That's a great question.
Yeah.
RLTA actually grants the surviving spouse the right to take over the lease,
Okay.
so they are not forced to move out during an already difficult time.
That's a really compassionate element of the act.
Yeah.
It's not just about the legalities.
It is.
It's about recognizing the human side of things.
Absolutely.
Yeah.
RLTA also lays out a clear process for handling the deceased tenant's belongings,
Okay.
involving a designated tenant representative.
Okay.
This could be a family member, someone named in the will, or even someone the tenant designated before their death.
Right.
The goal is to make a difficult situation as smooth as possible. It sounds like RRLT has really put a lot of thought into these complex and often overlooked aspects of renting,
For sure.
from security deposits
Yeah.
to domestic violence
Yeah.
to what happens after a tenant's death.
It is.
I'm sensing a theme here.
Uh-huh.
Clarity, fairness,
Yeah.
and a bit of compassion, too.
You're picking up what RLT is putting down.
Right.
And we've only scratched the surface.
Oh, there's more.
There's a bunch of other key changes that might surprise you.
All right.
You want to hear more?
Let's hear it.
All right. You bet. Let's dive into some of those smaller but equally important updates that ROL2 brings to the table. One thing that caught my eye is how it clarifies what types of properties actually fall under the Act.
Okay, so it's about setting boundaries, making sure RLOLT is applied where it's supposed to be applied.
Exactly. It keeps some of those exclusions from the original URLTA, but adds a couple of new ones that reflect how the housing market has changed over time. For example, it specifically addresses those short-term vacation rentals you see popping up everywhere.
Interesting. So that weekend getaway I booked through Airbnb might not be subject to the same rules as my year-long apartment lease.
That's right. RURLTA defines those vacation rentals as situations where the tenant is there just for vacation, has a primary residence somewhere else, the rental is fully furnished and ready to go, and the stay is less than 30 days in a row.
Makes sense. It acknowledges that those short-term vacation stays are a different ballgame. What's the other new exclusion?
The other one has to do with ground leases for mobile or manufactured homes. Think of those mobile home parks where the landlord owns the land and leases the space to a tenant who owns their own mobile home.
So RURLT is recognizing the nuances of different living arrangements. It's not a one-size-fits-all approach. What about staying in a hotel? Does that fall under RLT?
Nope, that's covered under what they call transient occupancy. Think hotel rooms or suites, where you pay a daily rate, you get housekeeping and fresh linens, and you're there for less than 30 days straight.
Okay, I'm starting to get a clearer picture of what falls under RLTA and what doesn't. It seems like they've really thought about how to make it relevant to today's housing landscape.
They've definitely done their homework. And another area where they've modernized things is in how notices are handled. No more relying solely on snail mail.
Oh, right, like those official notices for things like eviction or requests for repairs. Does that mean no more certified letters and trips to the post office?
You got it. RRLTA recognizes that we're living in a digital age, so it introduces the concept of notice in a record. That basically means notices can now be sent electronically.
So a landlord could email me an eviction notice.
It's not quite that simple. But yes, email is now a valid way to deliver notices. Think of it as a modern take on the traditional written notice. It needs to be electronically signed, which could be as simple as including your email address, and it can be sent directly to the recipient's email.
That's a huge time saver. No more wondering if a letter got lost in the mail or dealing with those certified mail receipts.
Exactly. Though it's worth noting that while electronic communication is encouraged, it's not mandatory. The Act still allows for those old school methods like personal delivery or snail mail, if that's what someone prefers.
Options are always good. It seems like RURLTA is all about making things more efficient and convenient while still maintaining that legal formality. So we've talked about types of properties and how notices are given. What else is new and noteworthy?
Well, another area where RLT tries to even the playing field is when it comes to attorney fees. In the past, the rules about this were scattered throughout the Act. RLT brings them all together under one section, making it super clear.
So it's like simplifying the rule book for attorney fees.
Exactly. And the main takeaway is that if one party decides to take legal action and wins the case, they can ask the court to make the other party pay their attorney fees. But there's a catch: the court has to agree that the losing party acted in bad faith, like they were intentionally trying to break the lease or just being difficult on purpose.
So it's not just about winning the case. It's about whether one side was deliberately trying to take advantage of the other.
You nailed it. This provision acts as a deterrent to keep everyone behaving reasonably. No one wants to be slapped with their opponent's legal fees, so it encourages both landlords and tenants to act in good faith and try to resolve things amicably whenever possible.
Makes sense. It's all about fairness and accountability. So what else does RRLTA address in its quest for a more equitable rental experience?
Let's talk habitability. That essential right to live in a place that's, well, livable.
Right, because having a roof over your head doesn't mean much if the place is falling apart around you.
Exactly. And RURLTA spells out in detail what landlords are responsible for when it comes to maintaining the property. We're talking about keeping those essential building systems in good working order. Plumbing, heating, electrical, the structural parts of the building.
So it's about meeting basic living standards, making sure the place is safe and functional.
Exactly. And it goes beyond just the physical structure. RURLTA also tackles essential services. Things like heat, hot and cold water, electricity, sewage disposal, even air conditioning if the law or the lease requires it. These are the things that make a place truly habitable.
So if my lease doesn't specifically include air conditioning and it's a scorcher outside, my landlord isn't obligated to provide it.
That's generally true, although you might want to check your local ordinances or regulations, as those can sometimes override the lease agreement in extreme situations. But the key is that whatever systems are in place when you move in, the landlord has to make sure they're functioning properly.
Got it. So if that AC unit was working when I signed the lease, they can't just ignore it if it breaks down.
Nope, they can't. RLTA holds landlords responsible for maintaining the property to that reasonable standard of habitability we talked about.
So let's say there's a problem with the property that the landlord is dragging their feet on fixing. What can a tenant do in that situation? Does RLTA give them any options?
It absolutely does. It outlines a clear process for tenants to address these issues. First and foremost, you need to put it in writing. Send the landlord a written notice of the problem and give them a reasonable chance to fix it.
And what's considered reasonable?
Well, for most repairs, the landlord has 14 days to remedy the situation. But if it's something serious, like a lack of heat in the dead of winter or a major safety hazard, that time frame shrinks to just 5 days.
So no ignoring a busted heater in freezing temperatures. Our RLTA is on the tenant's side when it comes to those essential needs.
Absolutely. And if the landlord still hasn't addressed the issue within that allotted time, the tenant has several options. They can choose to terminate the lease, withhold rent, recover any actual damages they incurred because of the landlord's negligence, go to court to force the landlord to make repairs, or even fix it themselves and deduct the cost from their rent.
Wow, those are some serious tools for tenants. It sounds like our RLTA is really empowering tenants to stand up for their right to a habitable home. But I imagine there are rules around how these options can be used.
You're right. RLTA is about fairness on both sides. For example, a tenant can't just stop paying rent without following the proper steps, giving written notice, and allowing the landlord time to address the issue. And they can't make huge deductions from their rent for minor repairs that they could have easily handled themselves. It's about being reasonable and acting in good faith.
It's a two-way street, right? Everyone needs to be responsible and communicative. What about situations where the damage is actually the tenant's fault?
Our RURLTA is clear on that too. If the tenant, their family, or guests are the ones who caused the problem, or if they're preventing the landlord from accessing the property to make repairs, then the landlord isn't responsible.
Makes sense. You break it, you or your guests fix it. It's about taking ownership. But what about those situations that are completely out of everyone's control, like natural disasters? I can imagine those throwing a wrench into things.
You're right, things like floods, hurricanes, tornadoes, they can cause major damage that takes time to repair. And that's where RLTA offers a bit of a safety net for landlords.
So even if it's not the landlord's fault that the repairs are taking longer than usual, the tenant still has options.
Yes, the tenant still has the right to terminate the lease if the place isn't habitable. But if they choose to stay, they can only try to recover damages for the diminished value of the rental unit while those repairs are delayed.
So it's acknowledging that sometimes things are truly beyond anyone's control, and it tries to create a fair outcome for both sides. What if the damage is so extensive that the landlord can't make the property livable again, even within a reasonable time frame?
Well, if the landlord can't get things back to a habitable state within 30 days, RLLT gives them the right to terminate the lease altogether. It wouldn't be fair to force either the landlord or the tenant to stay in that situation.
This whole section on habitability really highlights how much thought went into making RLTA a comprehensive and balanced act. It feels like they considered every possible angle.
They really did try to cover all the bases. And speaking of covering all the bases, there are a few more key areas of RLLT that we need to delve into. Ready to keep going?
You bet. I'm ready to keep exploring the depths of RURLTA. What other nuggets of wisdom have you uncovered?
Well, let's talk about something that can be a real headache for landlords. Tenant abandonment. You know, when a tenant just disappears without a trace, RURLTA actually expands on the original act to give landlords clearer guidelines on how to handle these situations.
So it's not as simple as a tenant turning in their keys and saying, "See ya." What else should landlords be looking for?
Right, there's more to it than that. RURLTA says that if the rent's been unpaid for at least 5 days, and it looks like the tenant has moved out most of their belongings and stopped utility services, that's a pretty good indication that they've flown the coop for good.
So at that point, can the landlord just change the locks and consider the unit vacant, start showing it to new potential renters?
Not so fast. Even if it seems like a clear case of abandonment, the landlord still has responsibilities.
Like what? It seems like the tenant is the one who's not holding up their end of the bargain.
True, but the landlord still has a duty to make reasonable efforts to find a new tenant and minimize their financial losses. They can't just sit back and expect to collect rent from a ghost.
Okay, I get that. But what exactly does reasonable effort entail? Does the landlord need to bend over backwards to fill the unit?
Luckily, our RLTA spells it out pretty clearly.
Oh.
They define reasonable effort as basically doing what you would normally do to rent out a unit that became vacant at the end of a lease. Things like advertising the unit, showing it to prospective tenants, that sort of thing.
So no need to offer crazy discounts or move-in specials just because the previous tenant skipped town.
Exactly. And if the landlord has multiple vacant units, they don't have to prioritize renting out the abandoned one over the others. It's about being fair and practical.
That seems reasonable. It shouldn't put landlords at a disadvantage because of a tenant's irresponsible behavior. But what happens if, even after making those reasonable efforts, the landlord can't find a new tenant right away?
Well, if they can show that they've done their due diligence, they can try to recover their losses from the tenant who abandoned the unit. Think unpaid rent, advertising costs, things like that. But if they don't make those reasonable efforts, the lease is considered terminated as of the date the tenant abandoned the property, and the tenant is only on the hook for whatever rent or damages occurred before they left.
It's like RURLTA is always striving to find that middle ground, that balance between protecting both the landlord and the tenant's interests. I'm impressed.
It's a tough job, but someone's got to do it. And speaking of finding balance, RLTA also tackles another tricky area, a landlord's right to access the rental unit.
Ah, yes, the whole "my home is my castle" versus "I own this property" dilemma. What does RURLTA have to say about when and why a landlord can enter a tenant's home?
Well, the general rule is pretty simple. The landlord needs the tenant's permission to enter, and it has to be at a reasonable time with at least 24 hours notice. No surprise inspections or popping in unannounced.
So no more landlords using that spare key to let themselves in whenever they feel like it.
Nope. RLTA puts a stop to that. But of course, there are exceptions. Emergencies, repairs that the tenant requested, routine maintenance, pest control. Those are all valid reasons for a landlord to enter without consent.
So if a pipe bursts, or I call about a leaky faucet, they don't have to wait for me to give them the okay to come in.
Right, those situations require prompt action. But even in those cases, the landlord still needs to make a reasonable effort to provide notice under the circumstances. And if the tenant's not home, they need to leave a note explaining why they entered.
That's good. It allows for quick action when necessary while still respecting the tenant's privacy. What about those routine maintenance checks or things like that?
If there's a preset schedule for those kinds of visits and the tenant was informed about it, the landlord can enter without getting consent each time. But if there's no fixed schedule, they need to give at least 72 hours notice.
So tenants can plan ahead and know when to expect those routine visits. Again, it's about clarity and open communication, which seems to be a recurring theme in RURLTA.
You're catching on. And that same spirit of fairness and transparency extends to the issue of retaliatory eviction, something that, unfortunately, some tenants have to deal with.
Yeah, I've heard horror stories about landlords trying to evict tenants who complain about problems with the property or try to assert their rights. That's just wrong.
It is, and our RURLTA steps up to protect tenants from this kind of abuse of power. It lays out a whole list of protected actions that a landlord cannot retaliate against.
What kinds of actions are we talking about?
Things like complaining to the landlord or a government agency about legitimate health or safety issues, exercising their rights under the lease or the act, even testifying against the landlord in court. Tenants should feel empowered to speak up without fear of reprisal.
Absolutely. It's about ensuring that tenants can exercise their rights without being punished for it. But what about those situations where a tenant might be making frivolous complaints or trying to take advantage of the system?
RURLTA has a safeguard for that, too. If it turns out that a tenant knowingly made a complaint that was completely baseless, the landlord can actually go after them for a penalty, up to 3 times the monthly rent. That's a pretty strong deterrent.
Wow, that's serious. So it's a reminder to tenants to be honest and reasonable with their complaints. But how exactly does RURLTA define retaliatory action by a landlord? Is it just about eviction?
It goes way beyond that. We're talking raising rent or fees without justification, decreasing services, refusing to renew a lease for no good reason, even committing a criminal act against the tenant or their guests. RURLTA is sending a clear message. Landlords can't use their position to bully tenants or silence them.
That's reassuring to know.
Yeah.
But how do you prove that a landlord's actions were retaliatory? It seems like that could be hard to do.
RURLTA helps with that too. If a landlord takes action against a tenant within 6 months of the tenant doing something that's considered a protected action, the law automatically assumes it was retaliatory unless the landlord can prove otherwise.
So the burden of proof is on the landlord in those cases. That makes a lot of sense. It makes it much harder for landlords to get away with bad behavior. Wow, this deep dive into RURLTA has been eye-opening. I had no idea how much this act covers. From those big-ticket items like security deposits and evictions to the more nuanced stuff like landlord access and retaliatory actions. It really does feel like they tried to think of everything.
It's a testament to the ongoing effort to create a more balanced and equitable system for both tenants and landlords. And while we've covered a lot of ground today, remember, this is just a starting point.
Exactly. If any of this has piqued your interest, or if you want to dig deeper into how RURLTA specifically affects your state, I highly encourage you to check out the full text of the Act. It's available online. Knowledge is power, especially when it comes to your rights and responsibilities as a renter or a landlord.
And hey, if you found this deep dive valuable, we'd love for you to hit that subscribe button. We're always exploring fascinating topics just like this one, and we can't wait to share them with you.
This whole conversation has got me thinking, what if RURLTA was adopted nationwide? Would it lead to more consistent and fair renting practices across the country? It's a big question, but definitely something to ponder. Until next time, happy renting or landlording.